The answer in this case is yes, but there's an exception to it. The reason is because let's just say this. It has to be unique. Is this confidential informant the only person that could buy into this organized crime group? Can I get Ed Tarver to get an undercover agent introduced so that we don't need this CI anymore? If this confidential informant is the only person who can get in, then he's very unique. And even though the private sector is paying for this CI, which happens all the time, we can use this confidential informant even though it's not traditional assistance. So what about the situation where it's storage costs? No matter where you go in the world, China, Brazil, US, storage costs are a big issue. This stuff is very expensive when you seize it before trial. So the question is well, can the private sector pay for storage costs? I used to give my best lawyerly answer last year if you asked me. I'd say it depends. But now we have some guidance in DOJ. And the guidance is yes, we can accept it, but it's not because it's unique like the confidential informant. We can accept it because there might be some sort of independent reason why the private sector wants to store these goods, separate from our criminal investigation. And this oftentimes comes up because there's no guarantee that the government's going to go forward on any particular prosecution. You might want to keep that evidence around for your civil proceeding. Well, that's every incentive for you, for your parallel proceeding, to pay for the storage of these goods. And it works out very well for government, especially if they can't afford to pay for the storage costs. A lot of times, and that happened in one case in particular, the government was paying for it. The private sector never indicated they wanted to go forward with a civil proceeding. The government didn't go forward with their prosecution and then just had everything destroyed. Well, it put the civil case in a huge problem. So you want to see if there's a uniqueness factor. You want to see if there's an independent reason. Now, keep in mind, it can't be a blanket. You can use our resources anytime you want. It has to be tailored to a very specific investigation. How does this play out? Pretty much on this chart. An offer comes in from the private sector. We want to refer this case. Here's all the resources we're going to offer you. You ask yourself, is this traditional assistance? The list we went over before. If it is traditional assistance, testifying at trial, turning over records, great. You go to that yes box. Then you shoot down and ask yourself, yeah, but do we have any Fourth Amendment concerns? Do we have any agency problems? And also, what are the appearance issues going to be if we accept this type of assistance in front of the jury, grand jury? If it's not traditional assistance, you go to that left box where you get no. You have to ask yourself, okay, it's not traditional. Do I have the exception? Is it unique? Is there a dual purpose? And if the answer is yes, right back to that Fourth Amendment box, appearance issues, but you can go forward. If the answer is no, then you end up in a situation where it's going to be treated like a gift. And gifts are not easily accepted by the Department of Justice. There's all sorts of restrictions that go way above my pay grade and scale to even to discuss with you. But if you're in this area, for example, cash donations, then there's going to be a much more intense procedure on whether or not those resources can be used. There is an exception to this, and this is one that a private sector attorney and a trademark association recently came to me with. They said, you said law enforcement always needs cash. We're willing to put up $500,000. We don't even care how you do it. We just know you're going to do counterfeit investigations, criminal investigations of counterfeit goods relating to our association, our trademark holders. And the question is can we take that money? And that's something we're considering now as to whether or not those can be used. Now, Rule 6E are the grand jury rules, and Rule 6E makes it such that federal prosecutors cannot always be as forthcoming as we might like to be when it comes to grand jury matters. This happens a lot. I get a call from a private sector attorney on an IP case, and he or she says, well, we really need those documents you subpoenaed to the grand jury because it is like going to make our case instantly. I said, well, I really can't give you those. There are all sorts of grand jury secrecy rules, and I explain Rule 6E. That's the bad news. The good news is that under certain circumstances, a prosecutor acting on behalf of the IP trademark holder or the attorney can go into court, and so long as you can show why they would be needed in very, very limited circumstances, the judge can issue an order and have those released. I went before the court and asked the judge to please allow me to release the eBay records in the Rockwell Automation case. They weren't going to do me any good, but I needed Rockwell Automation to see them. Now, does it help Rockwell's civil case? Probably, but I need it also for a criminal adjudication. And while we're on this topic, it's a little bit off topic, but you have to understand that the prosecutors have a client, and that's the federal government. And there are professional responsibility rules that prohibit